My lady, my lords, before the short adjournment, I was trying to explain what I meant by the fact that when the government issued regulations closing premises, they were doing the same sort of policing as a police officer does or a firefighter does when it closes premises in response to an emergency or incident. And I hope what I'm going to do now will answer my ladyship's point and sort of explain in a bit more detail what I mean by that.
Sure it will. Can I just find my pen so that I'm not missing the point? Thank you.
My lady, I'd taken the court to Lord Mance's award in China Taiping.
Yes.
One of the, and if I could just ask everyone to turn to page 140. And
sorry, can you just remind me where it is?
so, I'm so sorry. It's in volume 1 at tab 5.
Thank you very much.
And it's page 140.
Yeah.
One of the powers, and there are lots of powers here, and I'm not going to try and go through all of them, but one of the powers that Lord Mance refers to in paragraph G, in the middle of the page, is the common law power of police officers to cordon off an area, among other things, to protect public safety. And my point that I was trying to make earlier was that when a police officer or another authority acts in that way, it's not enforcing existing rules or regulations made by others. It's preventing access by taking action. And that is a power that a police officer undoubtedly possesses. Now, one of the other examples that's given in paragraph 85 of this award is to do with fire and rescue authorities. I think, if I may, what I'd like to do is just show the court the statute that relates to fire and rescue authorities. It's dealt with in paragraph 85B of this same paragraph in Lord Mance's award. And the reason why I take fire and rescue authorities is because it's often said of these clauses that the paradigm example is a gas leak or a fire. And so in our submission, a policing authority within the meaning of this clause, which is all about prevention of access to premises in response to a threat to life, clearly any policing authority encompasses the fire officers. And what I'm going to do is just ask if I could hang up, and please don't be alarmed by the size of it. I've just printed off the whole act, but I won't, I promise, take you to much of it, and I've given a copy to my friend. This is the Fire and Rescue Services Act 2004.
Thank you.
And it's the act referred to in paragraph 85B of Lord Mance's award. And section 1 of this just explains who the fire and rescue authorities are.
Yeah.
And then section 6, 7, and 8, which is headed core functions, explains what the core functions of fire and rescue authorities are. So in section 6, a fire and rescue authority can make provision for the purpose of promoting fire safety in its area, and then explains how it's going to do that. And then in section 7, a fire and rescue authority must make provision for the purpose of extinguishing fires in its area and protecting life and property in the event of fires in its area. And section 8, road traffic accidents. A fire and rescue authority must make provision for the purpose of rescuing people in the event of road traffic accidents in its area and protecting people from serious harm to the extent it considers reasonable to do so in the event of road traffic accidents in its function. Sorry, in its area. So those are what are described as the core functions of fire and rescue authorities. They're not about policing in the sense that the police enforce rules. Those are its core functions. If one then turns forward to section 44, which is on page 21, and section 44 provides powers of firefighters, etc., in an emergency, etc. An employee of fire and rescue authority who is authorised in writing by the authority for the purposes of this section may do anything he reasonably believes to be necessary if he reasonably believes a fire to have broken out or to be about to break out for the purpose of extinguishing or preventing the fire or protecting life or property. And then B, if he reasonably believes a road traffic accident to have occurred for the purpose of rescuing people or protecting them from serious harm. And then if he reasonably believes an emergency or another kind to have occurred for the purpose of discharging any function conferred on the Fire and Rescue Authority in relation to the emergency. And then if you turn over the page, section 2 provides that in particular an employee of a Fire and Rescue Authority who is authorised may, under subsection 1, enter premises, etc., and E, restrict the access of persons to premises or a place. And my point, my lady, is that, and there are other examples in other instances, but my point is that when a firefighter is preventing access to a premises in order to protect life, he's not enforcing existing regulations. What he's doing is he's taking action to prevent access in order to avoid or mitigate the threat to life or property. And we say clearly this clause must cover people like firefighters and traffic authorities who are empowered, have the authority to close premises in order to protect life. If it didn't, and this is all just about policing existing regulations, it becomes a completely different clause with very, very limited cover altogether. It's about closing premises when there's defective sanitation that doesn't comply with a rule. This clause is not about that. It's about when there's an incident, an emergency, an event which endangers life, and there is action taken in response by a policing authority which prevents access to the premises, that's when you have cover. We say a firefighter is a paradigm example of that. It doesn't stop being a policing authority because its core function isn't policing, because its core function isn't to enforce rules or laws. It's still a policing authority within the meaning of this clause, because all this clause is concerned about is not policing in the sense of enforcing rules and regulations. It's about policing in the sense of regulating, controlling access to premises. And my lady and my lords, that's exactly what we say that Matt Hancock was doing when, on the 21st of March, he passed regulations which closed a whole number of premises. This is covered in the agreed facts, but we think it might be helpful just to hand up the regulations themselves and the act pursuant to which they were made. And again, my friend is extremely familiar with these and he has copies. But if I could just ask that the Health Protection Coronavirus Business Closure Regulations, which Matt Hancock made, and the statute pursuant to which he made them, the Public Health Control of Disease Act, to be handed up.
Very much. Thank you.
Thank you.
So these were the regulations which were made on the 21st of March and came into effect immediately. And they were, in fact, then replaced by the 26th of March regulations, but they were all made pursuant to the same powers. And what it says at the start is the Secretary of State made the following regulations in exercise of the powers conferred by sections 45C, etc. of the Public Health Control of Disease Act. These regulations are made in response to the serious and imminent threat to public health which is posed by the incidence and spread of COVID, etc., etc. And then the final part, in accordance with section 45R of that Act, the Secretary of State is of the opinion that by reason of urgency it's necessary to make this instrument without a draft having been laid before and approved by each House of Parliament. If we look then at section 2, regulation 2, it provides, headed requirement to close premises and business during the emergency. A person who is responsible for carrying on a business which is listed in part 1 of the schedule, and part 1 of the schedule includes numerous premises including theatres, must, during the relevant period, close any premises. Oh no, I do apologise, that's actually restaurants. And it's actually subsection 4 which is relevant. A person responsible for carrying on a business which is listed in part 2 of the business must cease to carry on that business during the relevant period. And that was theatres as well as many other businesses. And then what we see in section 3 is that a person who, without reasonable excuse, contravenes regulation 2 commits an offence, and then an offence is punishable on summary conviction by a fine. And then in section 4, enforcement of restrictions and prosecution, a person designated by the Secretary of State may take such action as is necessary to enforce a closure or restriction. And the people who were designated included, and I'll be corrected by my learned friends on this, but police and local authorities and some other people. So there were people who were designated as responsible for enforcing rules. But what I say Matt Hancock was doing when he made these regulations restricting access to premises is exactly the same thing in substance as a firefighter or a police officer is doing when they direct people must leave premises or must not enter premises, or they cordon off an area because of a threat to life or property in that area.
Is there any significance of the term in section 3, subsection 2?
My lady, the person who obstructs...
A person who obstructs without reasonable cause any person carrying out a function under these regulations commits an offence. Does that feed into policing or anything like that? Because I don't think that you could say, could you, that it applies to the Secretary of State for Health?
A person who obstructs anyone carrying out a function under these regulations. So if someone obstructs a police officer...
Yes,
yes,
but does that have any relevance to the argument either way that you're promoting? That's a genuine question.
Well, my lady, this is a genuine answer. I don't know.
No.
I don't see it at the moment. Maybe Mr. Doherty will help us on that.
All right.
What I say is that where an order is made or a regulation is made by someone pursuant to powers that enables them to close premises, and they have at their disposal, and they make it an offence, they have at their disposal the police to enforce that rule, and they make it an offence punishable by a fine if the rules aren't complied with, they are acting, when making those regulations, as a policing authority within the meaning of this clause.
What are the functions under the regulations, and who are the persons who carry them out? It looks to me as if that's really a reference to paragraph 2, and the functions are closing the relevant businesses, and the persons who carry that function out are the owners of those businesses on whom the responsibility is placed to obey them.
Well, is
that wrong?
A person who obstructs without reasonable excuse any person carrying out a function under these regulations. So I confess it's a while since I looked at these regulations in this level of detail, but I certainly understood that to mean that because there are people who are designated by the Secretary of State to take action that's necessary to enforce a closure, which is section 4, the person who was carrying out a function was someone who was enforcing it. I think Mr. Doherty agrees, which is always good news.
Oh, maybe. Yeah.
So, Ms. Doherty reminds me that in the core bundle, thank you, at tab 9, we have the statement of agreed and assumed facts.
Yeah.
And at page 109, starting at paragraph 25, we have reference to the regulations that we've just been looking at. Paragraph 26 refers to the closure. And then, as I said, the 21st of March regulations were replaced almost immediately with very similar 26th of March regulations. And they're dealt with at paragraph 111, which is on page 111, starting at paragraph 32. And the regulation, the relevant regulation is very similar, requires the businesses to close. And then regulation 8.1, this is paragraph 37, provided relevant persons with the power to take such action as necessary to enforce any requirements. And the relevant person was designated as a constable, a police support officer, a person designated by a local authority, or a person designated by the Secretary of State. And then under paragraph 38, we've set out which persons, which people were designated as people who were relevant people for the purpose of Regulation 8 to take action. So certainly I have to say I have always understood 3.2 as meaning that if you obstruct someone who is requiring premises to be closed, then you commit an offence. My point about these regulations is if you're passing an order that requires premises to close, as I say, with the support of the police, and which it will be a criminal offence to contravene, you are carrying out the archetypal policing function in the sense required by this clause. And so we say that where the judge held that any policing authority means any authority that enforces rules, and there's a fundamental distinction between enforcing rules and regulating or legislating or making the rules or making the order of closure. That's a false distinction for the purpose of this clause. So we say, made the submission at first instance, and we make it again, that if the clause meant the police, it would have said the police. And in response to the rhetorical question, why not say the police if you mean the police, Mr. Doherty says, well, it allows a slightly more nuanced approach as to who is included. So it includes bodies that are carrying out policing functions. And so it appears that the test that Allianz promulgated is the body carrying out a policing function. And we say to that the other bodies which have power to regulate access to premises or areas, such as the fire brigade, highways authorities, etc., their general function isn't to police in the way that the police police, but they are policing when they prevent access to premises. And so in answer to the rhetorical question, well, is a fire brigade a policing authority? The answer might be, well, yes, it is, when what it's doing is preventing access to premises. It is then carrying out a policing function, and it's to be regarded as any policing authority. And we say, as I've already said, that my answer to that is that's exactly what Matt Hancock was doing when he passed the regulations on the 21st of May, ordering all premises to close.
Why was it necessary, therefore, to include reference in the regulations to relevant persons? designated by the Secretary of State. If the premises are not closed, this will be an offence, rather than someone designated being obstructed in their duty.
Because some people didn't close premises, and what this was doing was making clear which people, which went beyond the police, was more than the police, had power to enforce the rule that was being made.
All right. It seemed to me that they were policing the regulations, weren't they?
Well, my lady, I accept that if the police, and I think my learned friend accepts, that if my clients had refused to close their premises and the police had come along and said, shut down the Savoy Theatre right now, that would be prevention or hindrance of access by a policing authority.
Yeah.
I think that's common ground. And what we say is that the oddity of the judge's construction is that if my clients had done that, as some nightclubs, for example, refused to do, and had the police come along and required them to close the premises, they would prima facie get cover under this clause, because that would be the prevention of access by a policing authority. But when my clients, quite rightly, closed their premises as they were required to do by an order from the Secretary of State, they don't, because it's not a policing authority. And we do say that oddity really makes you think again about what is meant by a policing authority.
I think if you'll forgive me for asking this question, but might it be said that the word policing in this clause is a form of metonymy or synecdoche, because it's taking a part of the function and using that as its point of reference? That's the point you're making, I think, isn't it?
My lord, yes. Now, I do accept that the police, as I've said, fall within the scope of a policing authority. They might even be the paradigm example of a policing authority. But I say again, you don't construe by reference to the paradigm example. You ask what the words mean in the context in which they appear. And here, the context in which they appear is about prevention of access to premises. And you also have regard to considerations of commerciality and common sense. And as I've just said, I do say it leads to a very strange result that prima facie my clients would have had cover if they had waited for the police to knock on their door, but they don't, because they did what they were told they had to do by the Secretary of State.
Then I suppose you'd only have cover because you committed an offence.
Well, my lord, there may be arguments that insurers would make in those circumstances as to why we don't have cover. There may. But just looking at the scope of the clause and the coverage of the clause itself, it is being said that if the police had closed me down, then I would fall within the scope of the clause, and I don't, because I closed in response to the government. Turning to commerciality and common sense, what we say is that our construction, which gives a broader and context-based meaning to any policing authority, is consistent with commercial common sense, because the intention of the cover is to provide indemnity where access to the premises has been prevented or hindered by a body that had authority to do so. So the cover does not respond if there are widespread protests throughout London by Extinction Rebellion or Just Stop Oil or right-wingers protesting about immigration that have just put theatregoers off going to the Savoy Theatre. And it doesn't respond if management decide to close the Savoy Theatre in those circumstances because it's concerned about the potential for disorder. But if there were an order made that all hospitality premises in London must be closed because of those protests or riots, given the concern for safety, then the insured should have cover. And we say it can't sensibly make a difference whether that order was made by the police, in the sense of a police constable, by the City of London Corporation, pursuant to the statutory powers given to them to close premises, or by central government pursuant to the powers given to them. We say there's no commercial common sense in distinguishing this in this way. And the only relevant question is whether the type of body that prevented access to the premises had authority to do so. So Extinction Rebellion and Just Stop Oil would not count, but the City of London Corporation would. My lady, my lords, that was all I was intending to say on this ground, subject to any questions that the court may have.
No, thank you very much. Doherty.
My lady, my lords, I'll respond on the first two grounds of appeal, namely the instant and policing authority points, and I'll ask my learned junior, Mr. Killen, to deal with the third point, the more difficult point. I then, in your lordship and ladyship, hand in relation to what to do about the cross appeal, as to whether to start that or whether your ladyship and lordships wish to deal with that separately, completely. But we can perhaps see where I am at that point.
Yes.
Can I just make a few preliminary points? And that relates to the applicable principles of construction. They're not in dispute. The judge set them out in his judgment, and we don't need to turn it up, but it's paragraphs 103 to 105, core bundle, page 142 to 143. But I would just like to underline a few, hopefully uncontroversial points, because I say that they are relevant when we come to look at the specific questions, both under incident and policing authority. The first is obviously the well-established principle that this should be, the question of construction should be approached by reference to the reasonable reader, or as the Supreme Court has put it more recently, by reference to the ordinary policyholder. And that perspective, we say, is particularly important if the construction that is being put forward is one that we certainly suggest that even if linguistically available, is an unusual or a strained one. The second point is that in considering the question of construction, one needs to consider the question as at the time of contracting, not, and as I think my Lord Justice Males has already indicated, by reference to hindsight, but by reference to the time of contracting, which was obviously prior to the pandemic. And then thirdly, in the context of what this judge accurately described as a pick and mix policy, there is an obvious danger in trying to find coherence between stitched together clauses which may be absent. That is not to say the court shouldn't have regard to the wider policy, but it is also that the court needs to recognise the limits of an attempt at coherence. And those last 2 points, namely the need to avoid hindsight in the context of particular COVID and the awareness of the type of policy that one is considering, is one that this court considered very recently in the Bellini and Britt case, which is in the bundle. Again, we don't need to turn it up, but I just give the court the reference, Authorities 3, page 54, paragraph 34 in the judgment of the Master of the Rolls. Finally, in terms of the introductory points, it's important to consider all these questions in the context of the relevant peril which is insured against. This clause does not mention disease at all. The reasonable reader, when considering what was meant by the words used at the time of contracting, would not have any obvious reason to think why it should or should cover, or necessarily cover at least, cases of disease. Now that's quite separate from the question as to whether it could theoretically apply to a disease case. And I'll come to that. But it would be wrong to suggest that there would be any oddity to the reasonable reader in approaching this clause on the basis of whether there would necessarily be cover. That can, of course, be contrasted with a situation where one is looking at a disease clause or a hybrid clause, i.e. an insurance clause which specifically mentions a disease. There, of course, it may be very right to say that one needs to avoid a construction that essentially diminishes the role of disease to an extent where effectively it will never apply. And that perhaps was one of the criticisms that one may derive from the Supreme Court's decision in the FCA test case, that the insurer's construction there was effectively such as to render many of these disease clauses effectively redundant in the case of a pandemic. And that was regarded as a powerful reason of construction to prefer an alternative construction. That's not the position here. I'll come back to the relevance of the peril as we look at the individual elements. I would also just point out, because I don't think it's been pointed out to date, in this policy, there is in fact a specific disease clause. Again, we don't need to look it up. We can perhaps look at it when we see the relevant clause later, clause close by later. But I'll give your lordships the reference. It's supplemental bundle, page 131, clause Z1447. That is a specified disease clause, which is why it's not relevant here. It lists the diseases that are covered. COVID was not one of them. So with that, let me turn to IH's appeal. As the judge found, it really fails for two independent reasons. First, a case of COVID or having COVID does not amount to an incident for the purposes of the relevant clause. That's what IH appeal in relation to ground one. And second, access or use of the premises was not prevented or hindered by any policing authority. Access in this case, as your ladyship and lordship have heard, was restricted by central government in issuing the March regulations, and that goes to ground two. And our overall submission is that the IH's attempts to get round these two difficulties have involved them adopting a wholly artificial and strained approach to the language used, which we certainly say is inconsistent with the proper approach to be adopted to construction of these types of clauses. It also, in the context of incident, requires them to persuade you to depart from clear statements in the authorities. With that, if I can turn to the first ground of appeal, which is the question of whether a case or cases of COVID can amount to an incident likely to endanger life. Now, I think my learned friend took you to the relevant passage where the judge decided this. It's core bundle tab 11, page 217, paragraph 469. I think I can summarise it simply as this, which is the judge accepted that incident can sometimes be synonymous with event, but that it would be unusual to describe something as an incident which no one notices at the time. At paragraph 464, he specifically, 474, he specifically said that he considered that incident connotes a happening which is apparent at the time. One sees that in the middle of 474. I also consider the word incident in ordinary usage does connote a happening which is apparent at the time, often to very many people. So just correcting one point that perhaps my learned friend made a number of times, which was to suggest that the judge simply felt that he had to follow divisional court. The judge added on his own reasoning. He wasn't simply a position of saying, I will follow the divisional court. He set out the reasoning of the divisional court, he added his own reasoning, and indeed subsequently also considered the comments made by Mrs. Justice Cockrell, which he considered supported that conclusion. So turning to what we say incident means. Now, I of course accept that one needs to look at the incidents by reference to the clauses as a whole and in the context of the relevant peril. But let me start by just looking at the word incident on its own. Now, as I understand IEH's case, it is essentially that it is no more and no less than a synonym for an event or an occurrence. It's an entirely neutral word on its own. And we would say that is not consistent with ordinary usage. It can be used as a synonym, we don't dispute that, but it's not how it is normally used. And in particular, in terms of the relationship between an incident, an event, and an occurrence, we would say that to be an incident, there will always, as a minimum, need to be an event, an occurrence, or a happening. In other words, satisfying the four unities in the context of an insurance event or an occurrence. And that's all we say consistent with the approach of the Divisional Court and the Supreme Court. That minimum is uncontroversial. The question is whether it means something more. And we do say that it does. In the words of Mrs. Justice Cockrell, it adds a distinct colour. So whilst every incident is an event, not every event is an incident. And we do say, there's obviously a danger telling anyone what ordinary meaning is, because everyone comes to words with their own natural starting point. But we do say in normal use, it does denote something unusual, unpleasant or dangerous, often a synonym for accident. And one can see that in some of the dictionary definitions. Now, before taking the court just took one or two of them, I entirely recognise the limitation of dictionary definitions. In particular, the longer the definitions, the more the longer the entries, the more definitions one can find, and they don't necessarily point you in what the ordinary usage is. But we do say that one can find some guidance in the definitions. And so, for example, if we turn, we set some of them out in our skeleton, but if we turn to the authorities bundle where they are, and in particular tab 19, which I think is in the third authorities bundle, this is from the Cambridge Online Dictionary. It has the benefit of being a short definition. Page 835. Tab 19, 835. An event that is either unpleasant or unusual, and then with the specific examples, an isolated, serious or unfortunate incident, and it gives an example of a youth seriously injured in a shooting incident on a Saturday night.
But while an incident may be unpleasant or unusual, it doesn't have to be, does it? You can talk, as Ms. Higgs said, about an amusing incident or a curious incident. So this is simply not a correct definition of the word incident.
Well, I leave your lordship to write to the editors of the Cambridge Online Dictionary, but if your lordship's point is, of course, I accept that adjectives can change it and context can change the meaning. In a way, the advantage of this definition, simply as a snapshot, is we say what it does correctly reflect, it is the core definition. It's not that it can only mean this. I certainly accept that if one looks at much longer definitions, one will find a range of definitions, including
so you say, do you, that incident is inherently unpleasant or unusual unless the context shows the contrary?
The context or an adjective. It's more likely, again, like all things, I don't need to take this too far, because obviously I've got the whole clause to play with, but in terms of the core meaning of the phrase, yes, I do say, in response to the suggestion that incident is a purely neutral term, I don't accept that. I would say that the starting point of incident is that it has a negative implication, that it has the unpleasantness, the unusualness aspect of it. And if we go to the second definition I was going to take the court to, authorities 22, which is from the shorter Oxford English Dictionary, page 842. And we go to the first definition, obviously referring to incident in an entirely different context. But the second one, general, a distinct occurrence or event, especially one that attracts general attention or is noteworthy in some way, a matter or an affair, an event which increases international attention or may precipitate open warfare, a particular episode, a fracas, public disturbance. Something which stands out, I would underline there. Now, as I just said in answer to my Lord Justice Melson's question, I entirely accept that the phrase can then take flavour from broader context or a relevant adjective. So, for example, I'm using instant. I think my learned friend used the example of the curious incident of the dog in the night time, albeit I think that did involve a dog being stabbed by a pitchfork as the thesis of it. So it may not be the best example of a neutral incident. But of course, I accept the essential point, which is adjectively you can change it, and that as a matter of context you can change it.
These are two different starting points, aren't they? One is unpleasant, the other is stands out.
By the adjective, I mean, so as soon as one puts in amusing, then it becomes entirely clear. I suppose.
No, I was looking at the two definitions you've shown us. The first one, the Cambridge one, is that the unvarnished word means unpleasant, whereas the whatever this one is, the shorter Oxford,
yes.
Is that it is something noteworthy, which is a neutral term. It might be noteworthy, good or bad.
I take your lordship's point. Obviously, it goes on to talk about fracas and violent.
As examples,
so,
yes.
but I accept the point, and I also accept that if we were to put 20 more dictionaries before the court, one would find a number of different other definitions. So I don't want to take it too far, and of course I do. It's a point I was going to make later, but I'll make it now. Well, obviously it starts from this position that we already have 4 judges who do consider, as a matter of ordinary language, it means something different. We have Lord Justice Butcher, Lord Justice Flo and Mr. Justice Butcher in the divisional court. We have Mrs. Justice Cockrell, who considers it has a distinct colour, and we have the judge below, Mr. Justice Jacobs, again, who considers that it connotes something which is apparent. So, all of which goes against this notion that it's a purely synonymous question. Now, that of course doesn't mean that this court cannot decide that is not the correct first impression. But in my submission, the points I'm making are the reason why, as a reasonable reader, one comes to incident not as a neutral term. And I was going to give you the court just a few very quick examples. I'm not going to hopefully try the court's patience with examples, because I'll always come up with examples. But if I were to say there was an incident on my way to work today, that is not a neutral indication. That is an indication of something negative. If, on the other hand, I say something happened on the way to work, that is entirely neutral. Similarly, if I use the word event, that would be something neutral. If the police close a road to allow a planned demonstration, that would be an event. It wouldn't be an incident. Obviously, if they close a road in response to a riot, that would probably be described as in response to an incident. This is, we would say, a point about the importance of the flexibility of language. Yes, I'm not going to stand here to say they cannot, on some occasions, be synonymous. Of course they can be. It can be made clear by context or by adjectives that they mean the same thing. But in ordinary usage, it is not something that we would describe an incident as merely a happenstance or a occurrence. It means something more. Leaving home in the morning is not an incident normally. It would be a happening. It would be an event. Now, of course, we say one has to go further here in the context of this clause. First, we make the point that my learned friend's already touched upon, which is how incident is used in this particular clause. And if we could turn in that regard to the clause itself, which is at page, it's in the supplemental bundle, tab 2, page 131. And this is the point that there's the initial reference to the incident likely to endanger life, and that on the third line there's the reference to excluding any occurrence where the duration of such prevention or hindrance is less of use is less than 4 hours. And we do say here, and I don't want to labour this point, but we do say here that occurrence in this context naturally refers back not to the incident itself, but the composite peril, i.e., what's it referring back to? It's referring back to not just incident, but incident likely to endanger life or property within 1 mile, in consequence of which access to the premises is prevented or hindered by any policing authority. So when it then refers back to saying, but excluding any occurrence where the duration of such prevention or use is less than 4 hours, that's what it's referring to, not the fact of the incident, not the car accident. It's using it in a composite way. And in a way that underlines the difference in use within the clause itself, which we say supports our case. It's right to say that the judge found that this wasn't a point that he needed to decide. That he dealt with this at paragraph 477 of his judgment, because what he said was that on any view, it's clear that the use of the word incident here lent colour to the clause overall. So his conclusion was, whichever it meant, incident was the word giving the colour. We would suggest that one can go on further and say that the clause itself is quite clearly distinguishing here between the uses of the language. In the one context, incident occurrence is being used in a composite form. The second factor that we get from this clause is, of course, incident is not used alone. It is an incident that needs to be likely to endanger life or property. So here it is not just something which is unusual, stands out, but it needs to be something dangerous. Now, my learned friend has already indicated the types of example that one might say are the paradigm examples of this clause: gas leaks, traffic accidents, crimes that might take place. Now, we certainly accept that those paradigm examples of what you'd expect this clause to cover can't govern the interpretation of the clause. But they do help, we say, in understanding how a reasonable reader would approach this clause and understand it. Because turning it the other way around, if the construction we were putting forward excluded those paradigm examples, that might well be an indication that our construction is too narrow, unless the wording were very clear. By contrast here, though, there's nothing surprising or curious about an incident in a non-damage denial of access clause, not encompassing simply having a disease or contracting a disease without more. Now, the second element that we underline for the purpose of saying that an incident is not synonymous simply with an event or occurrence is this notion of it connoting something manifest, apparent, identifiable, detectable, as opposed to something which is unobservable or latent. So, putting it simply, we say an ordinary policyholder would not describe an undetectable, unobservable happening as an incident.
You don't have that in any of your definitions, do you? That colour.
Sorry, Maura,
that colour of the word incident, this idea of being observable, isn't in any of your definitions. I mean, noteworthy isn't really the same thing, is it? That's the only one that comes.
It's noteworthy. We certainly, the short Oxford English Dictionary talks about something, especially something which attracts attention.
Okay.
So we would rely on that as actually the core of the notion that you'd expect an incident to be something that you notice. I appreciate there's a limitation to all of these dictionary definitions because they're not purporting to do what we're trying to do here. But that's not to say that I'm trying to push what we would say the normal understanding or meaning is. My submission is, as the judge below accepted, and as indeed Lord Justice Flo and Mr. Justice Butcher accepted in the divisional clause, is it does have an additional element, that there is the element of something being detectable, being observable, in the notion of an incident, and something which is simply unknowable, unobservable, would not normally be characterised as an incident. And perhaps just to sort of take an example of what might be an event and what might be an occurrence and what might be an incident. One might, for example, say that a crack in some foundations or foundations of a wall is certainly an occurrence, maybe a key occurrence, but unless it's observable, it would be not normal usage would suggest to say that that was an incident. By contrast, the collapse of the wall would plainly be an incident, as well as being an event or an occurrence. Now, again, I would accept that that question of what amounts to an incident or an occurrence, or what is sufficient to be an incident, may well depend on the perspective of the person asking the question. So if you had an engineer whose job was to consider the safety of the wall, you might give a different answer as to whether the original crack can properly be characterised as an incident as opposed to an occurrence. It's dependent in that context. But certainly we would suggest an ordinary policyholder's perspective, or just a reasonable person's perspective, that is not something you would normally describe as an incident, an undetectable crack within the foundation. And if we turn to the COVID example, the examples which are before us, the question is a person who's just been infected with COVID, who's walking around London, who won't know whether they have COVID or not, will be acting completely normally, just as if he or she had not been infected. If anyone saw them, they would not know whether they were infected or not. Would that be characterised as an incident? And we say no, because it's both undetectable and undiscoverable. It's not realistically something that a normal person would describe as an incident. It's not. It wouldn't attract attention.
A normal person probably wouldn't describe it as an event or an occurrence either, but the Supreme Court seems to say that you have to.
Well, I think there are probably two answers to that. The first, obviously, at the moment, is the focus on the word incident, as to whether incident adds something. And your Lordship obviously has my submissions, which I'm developing, as to why incident does add something that is not the same. Whereas event and occurrence, I certainly would accept are neutral. Incident, we say, is not. It involves something more than the two. The other, of course, is one has to be careful when one says what the Supreme Court has decided. The Supreme Court's decisions in the context of occurrence and event were all in the context of disease or hybrid clauses. That they were not deciding that an occurrence or an event were necessarily sufficient to trigger what would have been a denial of access clause. I'm not trying to take it one way or the other, but they were separate questions. So just like this court recently in the context of the London Excel case considered that the question of causation needed to be considered very carefully in the context of the relevant peril, we say the same applies here. One has to be very careful to say that what is an occurrence or an event for one purpose, for one type of clause, is necessarily one for the other. Now, it's no part of my remit to argue whether it would in fact be an event or an occurrence if those words had been used. But I certainly say it does not follow that they would have used. It does not follow that they necessarily would have been. I don't need to go that far because I say instant already has a different meaning. But if the answer was, well, incident, occurrence, and event necessarily mean the same thing, I don't accept that in the context of this peril that would be sufficient for the insured.
Mr. Doherty, can I put to you that you might be yourself indulging in hindsight that you have rightly told us not to do? The reason I say that is this. If I ask myself the question, would it be an incident if someone, and this is a very lurid example, but that's to make the point, it was discovered that someone who had Ebola walked down Fleet Street through a load of crowds and therefore infected a whole slew of people with the Ebola virus, which is obviously the point of it is extremely unpleasant, deadly, and a very high mortality rate. That might well be called an incident, and that the reason why one can say to us now in 2024 that the idea of somebody walking down a street who may not have realised they had COVID doesn't feel like an incident is because we don't regard COVID now as anything like as serious as perhaps we did in March of 2020. We didn't know that there was going to be vaccines and everything else, and it was in fact a disease which was regarded as sufficiently dangerous that Parliament, that's not Parliament, of course, Mr. Hancock made the regulations he made. So doesn't one have to be a little bit careful with the hindsight there when one is looking at this word incident, which, as you put to us, contains this, perhaps contains a connotation of unpleasantness. It doesn't seem as unpleasant now as it used to.
Well, at one level, the more important point is less the unpleasantness bit, because of course I accept it, and I think my learned friend obviously accepts that in this case, incident is paired with endangered life. So I was referring to the unpleasantness really just to make clear why it's not synonymous, even before you add endangered life. But in this case, we know that what we're talking about is something that needs to endanger life. Mm-hmm. So the more important point, as the judge below recognised, is this notion as to whether it needs to be manifest in some way, that one needs to know about, it needs to be detectable to either the person or to someone else at the time. And so in answer to your Lordship's question, the answer would be no different for Ebola unless there were some manifestation of it. So I think the example given below was of a disease which does give rise to an incident. So this policy could respond to a disease. It's not that it can't, it's just it would be a very narrow range of case. If someone collapsed of COVID outside a theatre and an ambulance was called, that might be an incident. If there were someone collapsed with Ebola with blood out of their eyes and they closed the restaurant, that could be an incident. It's not that it can't be, but simply having the disease, however serious it is not the incident. Or contracting the disease. Again, it may be for other people's purposes. If you are a forensic scientist trying to work out how a disease spread, you might say the contraction of a disease is the incident that you're interested in. But in this clause, when one's looking at it as a whole, what's this about? It's about denial of access. We'll come to this, it's paired with policing authority and closing off roads. That's not what this is about. This is not about walking around with diseases. This is about, which is my submission, about something manifest, apparent, to which you can have a reaction.
But doesn't that just go to proof of the incident? The outward manifestation of the disease, for example, speaking about COVID for the moment.
Well, I think it raises two questions, because I think to a point that my learned friend raised, what would be sufficient for an incident? And the answer to that is, of course, we've never had to quite deal with that point, because the way that the case has been put has been very much on the black and white, merely having it is enough. Reason being that those are the easy statistics you can get of someone, whether they had it or not. As soon as you have to get into the detail of did people know about it, etc., it becomes much more difficult to prove. So that's not an issue that's actually been debated. Our case is that incident isn't simply having feeling a bit weary or having a cough. It is something more significant than that, the collapse out of the side of the theatre type example. That's really what's being referred to here. Now, we can obviously have an argument about that. For the purposes of this preliminary issue, it was simply put in a binary sense. Is it enough merely to have it and walk around irrespective of any knowledge, which is the claimant's case, which would be what would be sufficient for occurrence of the disease, for a disease clause.
So could you help me? So you say that Ms. Higgs's case is that regardless of any consequences, if someone was walking in Shaftesbury Avenue, because there was a statistical chance that they had COVID, that would be an incident.
No, I
didn't think she was saying that.
No. And if I suggest that, there are obviously issues about how you prove within certain mile radiuses whether they were in fact at the relevant time people with COVID or not. And there are various models that you can use which suggest how many cases there were at various points of time. But those are not cases, individual example cases of someone saying, oh, they had a terrible fever and they called 999. Those are statistical modelling, sometimes based on real life data, but quite mixed. And so, as I understand it, the claimant's position is it's very, very straightforward. It either, I think on Ms. Higgs' broad case, it's sufficient simply to be within the radius, or perhaps you don't even have to be in the radius, to endanger someone within the radius.
If you've got COVID.
If you've got COVID.
So it goes back again, doesn't it, to it would then be for the insured to prove that X or Y or Z who was within the mile radius had COVID. So it is possible to say an incident can occur of a single case of COVID, even if somebody doesn't faint or sweat or cough or anything, providing that you prove that the incident that actually transpires to be, or maybe from statistical mapping, led to the endangerment of life. I mean,
no, really, that's the difference. So the distinction is we say no, and why? Because we say incident has this notion of being observable, and that it's the point that the divisional court make that simply having it, walking around with it unknowingly, is not an incident. And so it doesn't matter whether you in fact have it and you can prove it. That's simply not an incident. It is what your ladyship is saying is certainly right when it comes to a disease clause and an occurrence. So yes, you can have an occurrence of disease for the purposes of the disease clause without ever knowing about it, in fact, if it can be subsequently proved that you had it. Yeah, that's the question is simply whether you can prove it. The relevance of the incident element is that it is adding on an element of we say, some form of observability, the ability to know that it was there. I mean, some of these, for example, clauses have the word manifested in.
yeah.
And so the courts have had, well, actually, manifested, you need it to be reported or diagnosed or something. You need an extra element. And in a similar way, we say incident here doesn't mean the same as specifically the same as that, but it requires something more. And one can obviously have the debate about whether it means, it really means collapsing outside the theatre type incident, or whether it's sufficient that you feel very bad about it and people think you look ill. But that's not the debate that we're having at the moment, because that was never the debate of the preliminary issue, because the debate on the preliminary issue was a much narrower one, a binary one. Is the fact of having it enough? In which case you're not interested in anything else, and we can use the statistical models which give us easy answers. Or do you need something more, which is what we say.
So, as I understand it, you're putting, and I don't mean it in a tendentious way, but you're putting a temporal element into the noteworthiness or the attracting attention, that it's not good enough for it to be noteworthy in retrospect. It has to be noteworthy at the time it's happening.
Yes, it needs to be...
That's right.
That is right. So it needs to be observable at the time, not necessarily observed. And this is the examples with the burglaries and the floods, etc. That the point, as the judge made, is not so much the idea.
What does observable mean if it doesn't mean at the time?
It does mean at the time, but my point is no one needs to in fact have observed it. It's an objective question of could it have been observed. So the burglary example the judge gave, even though it's only the burglar who does it, the burglar is aware of it. It's properly to be characterised.
So you meant not actually observed rather than observable. Yeah.
You're right, my lady. So not being observed is not the relevant question. The test is it observable? Is it objectively observable? If it is objectively observable or apparent, like a flood in the holiday cottage or the burglary, then that is sufficient.
So noteworthy in the sense of worthy of note, even if there is nobody there to note it.
Yes, it could have been noted. There's something to see. Something's happening. Whereas it is a sort of transfer of virus from one person to another, an incident. That's the question. It is walking. I mean, the two options the judge gave of the relevant question is either the transmission, contracting it, so literally breathing in some virus, is that an incident? And secondly, walking into an invisible radius of one of these one of these premises, so coming within a 1 mile radius. That could be an occurrence. Walking into a thing, that could be said to be an occurrence. Is that really an incident? And as I said, at the moment we're on the broader point about what's meant by incident, but obviously as one then ties it in with policing, authority, etc., we say it becomes clearer and clearer. But at the moment I'm sort of earlier on in the argument. But it does come down to is incident, if one's looking at it on its own, as my learned friend says, a neutral term that tells you nothing else. It's simply a fact of a happening, and so you don't need to know anything about it. Or does it go further, as the divisional court said it did, and as the judge accepted below, and connote something that is manifest observable? And we do say that that latter meaning is one that is the more consistent with ordinary usage, and it is a misuse, we'd say, of language to describe a breathing in of some virus for an ordinary person as an incident, or the walking in and out of a notional 1 mile radius as an incident, even if it might be a relevant incident for a public health official.
So if, I'm sorry to put this example to you, but so if on Wednesday during the lockdown, someone who'd been hitherto fit and well walked, because they were entitled to their morning constitutional, within a mile radius of Shaftesbury Avenue, and all of a sudden collapsed in the street, and the ambulance is called and all the rest of it, that you would say is capable of being an incident. Yes. And it's actually then what's observable is the effect of the infection,
yes,
rather than the infection
because
itself.
That's what the policing authority is reacting to.
Yes, so it's right. I see. And so if you take it to a burst pipe, if you've got a burst pipe that's under the foundations and nobody sees it, and it transpires from the camera that it's been there for donkey's years, the incident is the actual eruption which leads to whatever consequence, rather than the commencement of it. That's
Yes.
what you're saying.
And that's similar to my foundation example.
Yeah. Yeah. Okay. Thank you.
I'm not, my lady, I've obviously made this point now, but the next point is this one then ties what this meaning of incident with the context of this clause, which then presupposes a response by any policing authority. I'll come to what that means. And again, we would say, you know, what are they most obviously expected to respond to? They're most obviously expected to respond to manifest apparent risks. And tied to that, one also has the question of the causal link between the incident and the response, and how a reasonable reader would approach that. And again, the assumption to the reasonable reader of the link, the causal link, would be that you're responding to something manifest or apparent. Now, I don't take that too far in the sense of I accept that certainly in the disease context, I can have a broader approach to causation, concurrent causation. But that broader approach to causation, which can be taken in certain cases, we would say would not alter how a reasonable reader would understand what's meant by an incident when they look at the phrase as a whole. And obviously that's, we say, a fortiori, if we are right on what is meant by policing authority, and the judge is right by what is meant on policing authority, that simply underlines, we say, what is presupposed by something of an incident, and that why it wouldn't cover, one wouldn't expect it to cover simply unknowable cases of diseases. We say it applies anyway, but it's reinforced. There's obviously an iterative element between the two.
Presumably, for your observation, it's the policing authority that has to do the observing, because they're the ones who are going to close the premises.
Yes, that's exactly that's my point.
It has to be observable by the policing authority. It doesn't have to be observable by the theatre, let's say.
No, I mean I don't take these points too far, because obviously observable, obviously it can be transmitted, or police authorities can be told to take the action. But essentially, the reasonable reader will be looking at the link between a reaction by the policing authority to the instance. So yes, that would be the core meaning. I'm not trying to suggest that it can only ever be an incident which the police discover. I mean, if it's reported to the police and they take action, I would accept that might still be it would be context specific, but at its core, I agree with you.
Okay.
And then, when one steps back, it's relevant to come back to the point I've already underlined, which is the need to consider the peril insured by the clause. And so, repeating the point I made earlier, what is a relevant incident for the purposes of one type of peril might not be relevant for another type of peril. And your Lordship had my point that this is not a disease or hybrid clause.
Isn't the peril the incident?
No, the peril here would be the composite peril, which is if one has the
I see, the whole thing. Okay.
It's all the elements in causal sequence, I think we've been told by the Supreme Court. My learned friend made a point to compare this clause, clause 30, which is on supplemental bundle, tab 2, page 131, as a reminder, with the clause on the previous page, S29.1, page 130, and made the point that one has a specific disease exclusion and the other doesn't. Your Lordship, we already have the point, which is that we don't say that you can't have a case of disease within the scope of this clause. It's going to be quite narrow, but you have the examples of the collapse outside the theatre or the restaurant being closed by someone displaying symptoms of Ebola as potential examples where there might be cover under S30. It would be unusual because of the nature of the clause that there would, in fact, be cover. It's not saying that there can't be cover. My friend also mentioned that, referred to the Supreme Court dealing with incident in the context of other clauses. I think she expressly referred to the QBE clause, which the Supreme Court dealt with. Perhaps we can just look at that. That's at Authorities Bundle 2, tab 9. And it's page 438. So it starts, I think my learned friend took you to page 437. And I think gave this as an example of the use of incident in other clauses. One has the clause set out in paragraph 88 of QBE2. And the learned friend referred to H. The insurer should only be liable for loss arising at those premises which are directly subject to the incident. And of course, one looks above that, one sees that there is a reference to various types of peril, whether it's by reference to occurrence, discovery, accident, etc. So all the reference to incident and H is doing is acting as a compendious term, and we can see that the Supreme Court note that. The Supreme Court are certainly not saying that incident means the same as event or occurrence, suggesting anything like that. If one turns to page 438, paragraph 93, four or five lines down, we do not perceive any difference in meaning between the terms occurrence and event. Well, that's uncontroversial. And nothing significant is added by the use of the word incident as a compendious term instead of the phrase occurrence, discovery, or accident, used, for example, the definition of indemnity in RSA 3. We can see it's also used essentially as in H and QBE 2 as the compendious term. tells you nothing about whether incident normally means more than event. And as we've seen, all these observations are in the context of a disease or a hybrid clause. And I should say that the judge dealt with this point for completeness of paragraph 478. Essentially made the same point, didn't assist.
Can you give me the reference? Paragraph?
Page, it is core bundle 11. I'm afraid I think I'm missing the page number, but it's paragraph 478. I'll try and get you the page.
No, that's fine. I just missed the
219.
I just missed the paragraph number. I'm sorry.
My lady Lords, one can then derive, we say, further support for the judge's interpretation from the test case and then the dicta of Mrs. Justice Cockrell. In relation to the test case, my learned friend's taken you to the relevant passages and has already outlined that the divisional court were dealing with essentially two questions when it comes in this context on the Hiscox clause, which was the similar clause. There was the question as to whether the pandemic could count as an incident, and the answer was no. That's uncontroversial. But it then dealt with as the secondary case, and it did expressly deal with it. I think the learned friend accepts it, he says it quickly, that a case of COVID could also be an incident, and you've obviously seen what both the way that the submissions were put by insurers and how those submissions were accepted by the divisional court. Now, the key element being that it was not something that could be known about, and that it was in any event the mere presence of a case of COVID wouldn't be enough. So that takes us back to the sort of unknown, undetectable point. I think my learned friend says, well, there appears to be a contradiction there, because at one level the divisional court say incident has the same essential meaning as event and occurrence, yet they go on to say that it needs to be something which is apparently something which is knowable and detectable. And in my submission, the answer to that question is essentially the submissions I've already made, namely that whilst an incident will always amount to an event or a happening or an occurrence, the reverse is not true, i.e. it adds something. The second answer to that is the one I've again already touched upon, which is it must be remembered that what is being said here is all in the context of a non-damage denial of access clause, whereas the passages that my learned friend takes you to are all in the context of either disease or hybrid clauses, where disease is an element of the cover. And one can see why the arguments will be different if you're already starting off from the proposition that the insuring clause is intended to cover disease. That's not the position here, where one's looking at a clause which is looking at policing, a policing authority reacting to an incident by closing roads. And in terms of the question of the goalposts having been, or the point that the goalposts have somehow moved as a result of the Supreme Court decision, and somehow that might suggest a reason to reconsider what the divisional court said. Well, obviously this court isn't bound by the divisional court's analysis in the first place, but the essential reasoning, the essential analysis carried out by the divisional court, the essential answer is by reference to the simple wording. It's the reaction to the wording. Whether one calls that first impressions, if my learned friend wants to say that there's not a huge amount of analysis, doesn't actually undermine its value. It's first impression set out in the key judgment by two leading insurance rights. So we would certainly say that reaction to the meaning of the wording and the incident is a powerful one.
Mr. Dockery, forgive me, I'm just looking again at para 405 of the Divisional Court, which is what you're referring to.
Yes.
Yeah. And I hadn't noticed this before. Those last two sentences are where at the end of that paragraph is the crucial bit, I think, as I understand it.
Yes.
And the last sentence says, as Mr. Gazeman QC said, that person might or might not know that he or she has COVID-19. And that's what the two judges there are saying as part of the answer, to say that an incident, it is not an incident. But what is then said is that, and in any event, it is a misnomer to describe the presence of someone in the radius with a disease as an incident. So by saying in any event, that means, I think, that what's being said after it doesn't depend on what was said before it.
Yes.
Which means that when the judges there say it's a misnomer to describe it as an incident, they're not talking about the reason why it's a misnomer as being the person might or might not know that they have COVID. Because they wouldn't have said in any event if that's what they meant.
I accept that.
So what do they mean?
Well, I think we need to go back to what the submission was, because I think it's basically accepting Mr. Gainsman's submission on this. And if we go, I think my learned friend took you to this. If we go to page 336, back a few pages, paragraph 398. Sorry, it starts at 337, just over the page. So the submission was, likewise he submitted that the presence of someone within the 1 mile radius or in the vicinity of the premises who had COVID-19 could not possibly be described as an incident. The person might come and go without knowing he had the disease, and people might not know that he was infected. Such an undetectable happening could not be an incident.
Isn't that what they've just said? Is the thing they're saying without in any event? It's a misnomer.
Yes.
Even if those are true, it's still in any event a misnomer.
Yes. So you've got the question of you've got the initial point about whether the individual person knows it. So let's assume the individual person does know that they have COVID. Let's say they've done a test.
Oh, I see. You're saying it's because it's other people.
Yes. So that's the detectable point. The undetectable happening is the context of incident, we would say. But it's the two different elements that are put together. Sorry, that are kept, the alternative points that are made.
Thank you.
And my submission is that there's nothing here. This is answering the specific question of a case. So it's not considering the pandemic. It's considering the specific point of a case. There's nothing here which is overtaken by the Supreme Court causation decision. Causation is obviously a separate question. This is on the premise that an individual case could be enough. If it had been enough, then the causation decision would have made a difference on appeal. But it's considering them separately. We know it's considering them separately from the question of causation. It's not confusing causation on this, because we can, if we go to paragraph 418, we can see that the Supreme Court says another problem with it is it would fail for causation, the individual incident analysis. So it's not sort of mixing up the two concepts. It's dealing quite rightly with what does incident mean and what does causation mean. So we can't say it'd be wrong to suggest there's any sort of confusion by the divisional court on this question. And indeed, I mean, in a way, that's the key point about Corbyn and King, because my learned friend relied on the Corbyn and King decision of Mrs. Justice Cockrell and for other purposes. But in relation to this, said, well, Mrs. Justice Cockrell was really referring to another clause and was not directly considering the Hiscox clause. That's correct. But the reason why she was having to look at the clauses was to understand the extent to which the points had been properly argued and could remain, and could stand, in the context of the Supreme Court's decision. And what's notable is that while she was saying that certain decisions, in relation to certain clauses, the goalposts had moved, in the context of this clause, and we'll come back to it, she expressly said, well, incident does have a certain colour, and yes, certain factors in a clause may also make a difference to the paradigm that's expected to be covered. So there's an express, and we say correct recognition, but there's nothing about the Supreme Court decision that moves the goalposts on this. Well, this court can obviously come to a different conclusion that it simply means something different, but it would be wrong to suggest that the justification for a different view would be because the goalposts have moved. That would suggest it would not be correct. So perhaps just having made that point, if we can just briefly go to Mrs. Justice Cockrell's decision, which I think you've seen briefly. It's tab, bundle 1 of the authorities, tab 6, page 180. And the key point, just to underline here, if your lordships look up above 156, you can see that Mrs. Justice Cockrell has analysed carefully each of the wordings which were considered by the divisional court. So making good the point I was making earlier, she's sifting the clauses by reference to ones which have been undermined and those which haven't been undermined. And in relation to the Hiscox wording, and certainly in relation by reference to the word, one sees what she says there between H and J, down to J, on paragraph 156, which I won't read out again. In my submission, the way to read that is she recognises the force of the argument that was both made and accepted by the divisional court. And picking up the second point, just
though her final point on paragraph 156, citing the sentence that the FCA's entire case founders on the requirement for an incident, is referring to the case that the pandemic as a whole was the incident, wasn't it?
No, that would be both. So that's the introductory sentence to that section, which then has the two elements of it. So there's the pandemic argument, which was the main argument, that an incident, pandemic amounts to an incident, but it also covers the case argument. So it's a chapeau for both arguments. And in relation to paragraph 157, one has the additional point pointing to the paradigm, i.e. what you would expect to be covered, which is some form of authority wording. And here, of course, we have the policing authority wording. So again, we would suggest pointing to the paradigm of whether it's gas leaks, road traffic accidents, crime, etc., with a short franchise period. What is over the page? In this case, we have a 4-hour franchise period. The franchise period being the element of time that doesn't count, effectively the excess that you need to have before you have a claim. So in this case, it's 4 hours. You need to have 4 hours of interruption before you have a claim. Once you've had interruption of more than 4 hours, then you have cover from the ground up, but you need to reach that 4 hours. And it basically makes it cheaper because it means you don't get cover each time there's a 20-minute closure of the road.
So you're saying that points away from, or points to an incident, because an incident would normally be more than 4 hours?
So what we're saying is this points to what Mrs. Justice Cockrell said, anyway, the paradigm situations of the gas leak, etc., and that you would expect, so not the national type reaction. You're talking about a relatively short franchise period of 4 hours. I think in Hiscox, for example, it was 24 hours. Equally, you're talking about a an authority which is effectively one that you would be expecting to react locally. It doesn't answer the question whether it could be as a matter of government police at this stage, but it's pointing in that direction. Both of those point towards the local incident, and again, what we say is that the notion of something being apparent, observable, etc. My learned friend said that that we had some financial ombudsman service decisions in the bundle. There are some. I wasn't going to take the court to them, other than perhaps just to make the point that these are clauses or similar clauses that have been considered by the ombudsman. The only point I suppose that I draw from it is, as this court probably be aware, the ombudsman is not bound by the strict law. They take into account the law, but they're not bound by it if they don't consider it gives a fair, just and reasonable outcome. And the point I want to make is they have been considering that this wording does not react to cases of COVID. And they're in tab in the authorities bundle, in the third bundle, tabs 27 and 28. One has expressly incident wording, the other one uses the phrasing emergency event, but the ombudsman equates the two, essentially, emergency event and incident, and analyses them and says does not consider that it's reasonable to provide, or does not consider that there is cover under the policies. Again, I don't make more of them other than to, insofar as the argument is made against, as it sometimes is against insurers, and insurers are taking highly technical points that are unjust. It may be just right to say that the ombudsman has not been finding that these are clauses that are somehow unfair or unclear from their perspective. But as I said, I take that point really no further than that. In terms of some further points made by IEH, there's the point that an asymptomatic case of COVID-19 can be an occurrence, and the answer is yes. We accept that an asymptomatic case can be an occurrence in the context of a disease clause, but we say it simply doesn't help one way or the other as to whether what incident means, still less what incident means in the context of a non-disease clause. It really just comes back to the point, repeating the point of IH, that they ought to be synonymous, and we say no. They involve different language in different contexts and different clauses. My Lady and Lords, I think that's what I had to say on ground one, unless my Lady or Lord have any further points on ground one.
No, thank you.
And I see the time, so this I've probably gone over anyway, or I'll transcribe a break.
Right. All right. So 5 minutes.
All right.
Cot rise.
So we're going on to 28.3.
Policing authority, yes.
Oh, we're going to
No,
policing
policing
authority.
If you prefer to hear from Mr. Gillen first on the question of the location, I'm very happy to do that. Otherwise, I'm going to do the two threshold points.
Oh, sorry,
Basically,
I'm
instances
really
of-
sorry. I thought you said that Mr. Hillen was going to do the policing authority and you were going to do... So it's
Yeah,
my
I
fault.
was leaving
Sorry.
the difficult bit for him.
Right, okay, I'm so sorry. So, yes, because it goes naturally together. If you answer Miss Higgs's 2 points that she put together. No, she didn't. She
She kept them
yeah,
separate, but they're
yeah,
the
she
two.
did.
They're the two
Yeah.
threshold points. That
Yes.
The
Yes, the ones that
IH
she
succeed.
recognises she must succeed
Yes.
on both. Yes. Right, okay.
Can I just ask this so that you can think about it and tell us the answer later? Ms. Higgs accepted that she needs to win on both of what you call the threshold points. If we were to decide that you win on one of them, I'm not reached any concluded view about either of them, but if we were, is there any necessity or utility to deal with the other points, or indeed the cross appeal, because the claim against you then is knocked out, and no claim on this clause will succeed. So I just wonder what the position is there. Perhaps you'd like to think about that and tell us.
and take instruction. I can give your lordship the initial answer, but probably a more useful answer will be one with instructions rather than the initial answer. I will give your lordship the answer
Yes.
to that question.
Thank you.
So turning to what's meant by policing authority, and which means how would a reasonable policyholder read the reference in this clause to any policing authority. And we say that the judge was entirely right to conclude that it didn't refer to central government or the Secretary of State, Matt Hancock, but instead refer to the police or other bodies whose function is to ensure that the law is obeyed and enforced. And we do say that the judge's description of IEH's construction of policing authority as being a very considerable stretch was itself a bit of an understatement, because we say in the context of this clause, it is not a meaning that, despite my learned friend's extremely skillful submissions, we say is realistically open. We say that there is a straightforward meaning. It means those with authority to carry out policing, or put another way, policing authority means an authority who polices, i.e. To maintain order, to police, to preserve and enforce the law, operational matters relating to policing, day-to-day policing, all compared to setting out regulations to be obeyed by the community at large, and seeking to equate, and I'll come back to this, the imposition of a police cordon or a fire brigade cordon with setting out national regulations, we say has an air of unreality. The definition that we rely on is one that finds support by classic dictionary definitions. You just take your ladyship and your lordship to it very briefly. If you take the authorities bundle 3, authority tab 24. It's the new tab 24, which I think is at page 882, so it's the very end. And we'll see it on. I think this is the definition that was before the judge below, and we see two definitions of policing, quite similar. Policing, the further definition in police, to control, regulate, or keep in order by means of a police force or similar body, which provide was a police force, and then policing, noun, the action of providing or organising a police force or similar for the maintenance of law and order, the maintenance of law and order by means, etc. And if we then go to the more detailed entries, as often one has to be a bit careful with definitions, because if we go to page 883, which is the start of the definition for police, one should note that the first two or three entries are all described as being obsolete, so one has to be careful about which definitions one chooses. But if we go to page 884, one finds the core definitions which were described earlier, 3A and 3B. And if you then turn on to the definition, the further, more detailed definition of policing, which starts at page 889, one starts with various, again, obsolete definitions. And what's now described as a rare definition of cleaning and keeping in order a camp, which apparently is a US military expression, before getting to the more classic definitions, page 890 at 4A and 4B, the action of providing, organising a police force or similar body, etc. And we say this is the clear candidate for what we are talking about here. Now, as my learned friend recognised, one can obviously argue about where the edges of policing authority lie, and we accepted below that policing certainly could in principle extend beyond the police proper, narrow definition of police, i.e. I think the 43 territorial forces of England and Wales, I think there are 3 national forces as well. We said it focuses on function rather than precisely the title or status, and some of the examples given, highways authorities, border force, emergency services, we would accept might have policing functions. But equally, one needs to be cautious about that recognition that it might extend beyond just the police, to turn, perhaps what my learned friend was doing, to turn the definition on its head and to focus on those other functions, as opposed to what one might say are the core policing functions.
So, just take the gas leak. Let's say the fire brigade show up and say that the premises have to be closed because it's dangerous because of a gas leak. Do you, I mean, maybe you can't answer it, I don't know, but do you accept that that's within the clause or not?
I accept that. I mean, your lordship's right, but I suppose I don't have directly as to precisely what the circumstances are and what powers being related, but I certainly see that it might be, because I accept that might be carrying out a policing function, because the question is, right, I can take a narrow case and I can take a broad case, but the narrow case, which I take if necessary, is to say really it has to be akin to strict policing, and insofar as it is beyond that, that's going too far. So that's the strict view. In my submission, one can go wider than that, and as the judge appeared to go, which is focus on the function. And as I understand what my learned friend sought to say as well, closing off in that context is not sort of classic policing of enforcing an existing law. But in my submission, what it is doing, and I'll come back to this, is exercising an existing power and duty, in the context of the fire brigade, safety in relation to fire, It's not setting out some general regulation or law and seeking to equate a police cordon or a fire brigade cordon with the Secretary of State setting out national regulation. It is, we say, simply unreal. They're different functions. One is within the operational control of a body which, on this broader interpretation, would include policing the roads and access to premises. So on the operational basis, the one-off basis, the specific basis, if I can put it like that, dealing with the specific case. The other is setting down law, rules, regulation.
I don't want to badger you, but can I just push this one stage further? The point of the question is that the fire brigade don't enforce the law.
Yes.
I think I'm right in saying the judge's decision was that what characterised policing authority was law enforcement. So on the judge's decision, the example of the fire brigade would be not within the clause, because the fire brigade are not carrying out any. They don't do law enforcement, and they wouldn't be doing law enforcement when they close the premises because of a gas leak. So if you'll forgive me, like I say again, you don't have to answer this question, but I think you do accept that the example I gave of the fire brigade would be within the clause.
Yes,
the judge's line that he's drawn in the judgment isn't right.
Well, I think the judge is right about what the focus of the clause is, and as I indicated, if necessary, I'd take the narrower view. If I'm wrong on how one interprets the broader view, as in one can take simply precisely and say, well, it's only if it is akin to precise police function of enforcement of the law. I may be wrong. I don't remember this being argued as such in front of the judge. Certainly the fire brigade example, because I don't recall being put in this way in front of the judge. So that may explain why. There was the police cordon example, but not these other examples in terms of the authority. So I think there may be an element of why it's perhaps unfair to say the judge didn't consider these options, because I don't think they were expressly explored in that way. But as I said, I would draw the two distinctions. One can have the narrow view, which is the judge's, how the judges put it, which I certainly think is sustainable. I would say that one can go broader than that, because the distinction that my learned friend seeks to make about saying enforcing the law only is not, we would say, a necessary element of policing. It's a core element of policing, but as my learned friend said, a core element of policing, we would also say, is protecting public safety. And merely saying that protecting public safety isn't enforcing the law doesn't mean it's not a core element of policing. And so putting a cordon around to protect someone from falling into a hole or to stay away from some chemical leak is part of a policing function, we would say. And akin to that, a fire brigade doing the same thing to keep someone away from a chemical leak or a fire can be characterised, we say on the broader case, as a policing function. And in my submission, but that is all different, even if, and as I said, we can have a debate about whether it should be narrow or broader, and I accept the judge put it narrow, I think, because of how it was addressed, but even if it's broader, none of that broader point of saying, well, because you're not doing it with a view to enforcing existing rule, it can't be said to be policing. Therefore, it's equivalent to Matt Hancock setting out regulation. We say simply doesn't follow. That's just a non sequitur. Why? Because they're fundamentally different in character. Because a police officer or a fire brigade are exercising their operational function, which involve a number of things, but include for both of them protecting the public and safety. That is what they're exercising that power. They're not setting rules or regulations for the future. They're exercising an existing power on an individual basis. That is policing. We would say that's a core element of policing. And it's a submission I was going to make later, but this may be an example of where lawyers might find this question more difficult than members of the public. Because ultimately, if you ask any one member of the public, the idea that it would be any form of policing for the Secretary of State, and that's really the question we're talking about, is government including this? That's the narrow question. The answer is, we say, entirely obvious, because essentially for the core reasons given by the if one needs to expand upon them to deal with the sort of broader range of circumstances, all the things a policeman can do and all the things that a fire brigade might be able to do under the powers, it's the recognition that they are still performing their operational role on existing powers. They're not getting new powers, they're just using their existing powers, and they're not setting any new legislation out. Whereas that's exactly what the Secretary of State was doing. Yes, it was a statutory power, but he was setting out, by way of secondary legislation, the specific obligations on members of the public. But in a way, the answer, of course, to the broader question of policing authority doesn't, though, answer another point which was put, which is, I think, the distinction with it's Clause 29, which refers to the police and government and local authority. Why doesn't it just say the police? Because it can be broader, is the short answer. So that point, that comparison with the earlier clause, which, as I said, is dangerous anyway because of the pick and mix nature of these clauses, is in any event not a good one because it is expressing something very different. So, pulling in a way that core bit, because your Lordship's question, if I may say, in a way is the core question. A reasonable reader looking at this is going to see that legislating or issuing regulations is fundamentally different from someone policing those rules. We'll comes to what policing those rules means, but it's the distinction between making rules and regulations and normal policing, normal acting as a fire brigade, operational matters, using the existing powers. The general, which is legislation, and the specific incident in this case, but the actually reacting in accordance with the existing powers of a statutory or common law that they have. And as I said, that's not a distinction, I would suggest, that would trouble the reasonable reader. That would be an easy one to draw for the easy reader. They would know that what Mount Hancock was doing on the 21st and 26th of March was something very different from policing.
So you rely on the suggestion on 889 that there is a comparison to be drawn between policing and policy making. If you look at the bottom, at the top rather, with sense 1, compare also policy. Do you see it under
sorry,
etymology?
It's my fault. 889.
889, yes. Do you see it right at the top?
Sorry, the lady, I do. I would only say sense 1, of course, under 1, which is the Scottish derivation. But it seems to be with sense 1 being the Scottish. I may be misreading this in terms of sense 1 compare with policy.
I think the point is that in Scots law, policies means the woods around your house and things like that.
Yes, and it does also say obsolete. I'm cautious about. I'm not entirely sure what the sense 1 it's referring to. It may be it's referring to the sense 1. No, I was about to suggest.
But that's actually what your argument comes to, that the government is concerned with policy rather than policing.
Yes, or legislation, policy stroke legislation, and policing is the individual act. I mean, in fact, my learned friend in a way put it quite nicely at one level, where she was saying it's about action. Yes, police and fire brigades take action by reference to their existing powers, whether statutory or common law, whereas in this context what we have is legislative steps taken by Matt Hancock in response to the pandemic on the 21st and 26th of March. That they are materially different. They're not similar. Whilst we can try and say, well, they're both somehow rules. I think my own friend referred to cordons as orders, police orders. Well, yes, it may be right to say you're ordering someone not to go through, but the idea that it exists anything other than the declaration by the police officer not to come through it is unreal. It's a specific response to an incident. It's not some form of general lasting regulation or order of the type that is being referred to. And that's the distinction, that operational casuistic approach is, we say, just different from that which was being exercised by government in this context. And when one looks at the other points that are made, I mean, there's a reference, I think, in the skeleton to the fact, and I think it's a point my Lord Justice made as well, that this should all be given a wide interpretation. And I think the skeleton specifically said it should be similar to statutory authority. And I think my Lord Justice Mell said, well, do you really just mean authority? And quite, we say, because that it really is exactly what is being said. It's taking away any form of meaning to the relevant qualifier of policing. And indeed, it's actually very similar to the criticism, or sorry, the response of Lord Mance in the China Taiping case, where the insured, as Lord Mance put it, sought to avoid giving the word local authority any meaning and really just focused on authority. Perhaps just give you the reference to that. It's a short point. It's Authorities 5, Bundle 1, page 148, paragraph 107. And it's in the middle of the paragraph. While superfluidity or duplication of language are considerations on which too much weight should not be put when considering the meaning of standard wording, it is in fact also the case, as the insurer points out, that it's difficult to see that the word local, of course, local authority, adds anything to the word competent, in the policyholder's interpretation of the policy. And we say a similar point here. It's simply denuding the relevant qualifier of any proper meaning. My learned friend also made the point that the insured could have avoided all this by simply choosing not to close and getting the police to come and close them down. And that shows the absurdity of the construction that we're relying on. But of course that doesn't work, not just because of the illegality point, but also because of the lack of fortuity point. I mean, if in fact you know you need to close and you choose not to, well, there's no fortuity which would respond. So we would say that's not a good example in this case. I know from it, he also relied, and I think perhaps also in the context of instant wording here, but in the skeleton, certainly in the context of the policing authority wording, on the fact that the wording provides for 3 months for the maximum indemnity period. So essentially you can have your loss of profits for up to 3 months from a closure. And I think the suggestion is, well, that's a very long period, and that is pointing you away from the classic local closure from a road traffic accident, and it perhaps more of the sort of thing where you'd expect government reacting. I think that's the sort of the rationale that's being suggested. But we don't accept that point. Clearly, you can envisage long periods from gas leaks etc. Of course, the 3-month maximum indemnity period is not about how long the incident itself lasts for. It's about how long you suffer consequences from the closure. So let's say you're closed for a week because of a terrible gas leak and the roads had to be closed and not being able to open your shop. You might well say, well, actually, the effect of being closed for that week, perhaps a better point if you're closed for 2 or 3 weeks, is that your regular shoppers have started going elsewhere. And actually, the consequences of being shut for that 1 week, 2 weeks, or however long it is, stretch on beyond the closure. So there's nothing unusual about that. And indeed, one gets cases. I mean, I think below, in the court below, there was discussion about the Salisbury incident and the Nova Shop. I think in that case, the shopping centre was closed for 11 weeks following the contamination argument. So you can get quite long periods. None of that, we say, helps with the construction of the clause.
I know we have to construe the clause as a whole, but it's hard to think that the meaning of policing authority would depend on whether the maximum indemnity period is 3 months or 1 month.
Precisely. And to be fair, I don't think my learned friend tries to say this is her best point. I think the point that's being made is it's a point in support, a small pointer, in favour of of policing authority being given a broader meaning. We simply say it's no pointer at all in relation to that. Another point made is, and this is a sort of iterative point, is that if it's right that incident includes a case of COVID, so my own friend succeeds on her first ground of appeal, then that should help construe what policing authority means. Now, obviously, the first point is the one you'd expect me to make, which is obviously, yes, it is iterative, but it goes both ways. Obviously, we do say that the meaning of policing authority does influence what an incident means as well. But I accept, obviously, it may not be irrelevant. But perhaps the biggest point on this is, even if my learned friend is right on incident, so we've had the iterative exercise of which influences which, the court has concluded that incident includes simply a case of COVID, irrespective of whether anyone knows about it at the time. The fact that in a very unusual case, you might have a disease that qualifies as an incident in the context of this pandemic is very unlikely to meaningfully assist you with interpreting the clause. I mean, it'd be a classic case of tail wagging the dog. You know, the mere fact you manage to get something in to the interpretation doesn't then suddenly change the fundamental construction of the clause. And it certainly doesn't, we would say, help you with the notion that policing authority would be more likely to be construed as including the government, or Matt Hancock, than the other bodies which we say would qualify. And I think the similar argument is made in the skeleton in relation to this point that the clause includes incidents outside the radius which endanger life within the radius. And again, I think it's suggested that this more remote effect would again suggest that when I was looking at a policing authority, one might be looking at a body which is less local and more national, like the government. But again, we're not really relying on the local element of the force here. That's not the key element here. It's the function of policing, whether that's the narrow function of simply enforcement, or, as I'd be prepared to accept, the slightly broader approach that one could also say, and which are part of the operational roles that classically a member of the public would describe as part of policing, keeping people safe, applies as much on either option. The fact that the gas leak is slightly outside the 1 mile radius or within the 1 mile radius doesn't meaningfully help you decide as to whether policing authority is pointing to some other form of body. And then, my learned friend didn't make these points orally, but in her written submissions, gave other examples of the use of policing, I think, policing children, or a GP receptionist policing patients, as examples of the use of language which could encompass a broader range of cases. And we would say, well, we rather say this shows how divorced from reality this all is. Obscure and unusual uses in other contexts simply doesn't help enlighten what this clause means. And you'll obviously have my submissions already as to what it means in this context as a straightforward orderly meaning that we say that members of the public would readily understand. Lady Mills, I think that's what I had to say on policing authority. I see the time.
So, thank you. We're not going to call on Mr. Killen now. So we'll do that first thing in the morning if we may. Would you just give me one moment, please? Yes, just so that Miss Higgs knows, the question of my lords was whether or not we would ask you to reply, so that we deal with the appeal all in one. And I think we would still all feel it a benefit to keep all of the arguments together. So may we put you on notice to that, and also you, Mr. Doherty, that you can rest a while before we go to consider a cross appeal.
Not for very long.
No. No. All right. Thank you very much. So 10:30 tomorrow. Thank you all very much.
All right.